Welcome to another episode on the Law Rapport. This is episode 11, and today I would like to discuss defenses in criminal law. But before I get into the discussion, the usual disclaimer: this is not legal advice, should not be construed as legal advice, and for legal advice, please contact a competent attorney of your choice. Now, in criminal law, the mere fact that a person is arrested and charged does not guarantee a conviction. A defendant charged with a criminal offense has the right to put forward his defense, and it is the prosecution that must prove all the elements of the offense, particularly the intent element. The defendant has the opportunity during the trial, whether by calling evidence, by giving evidence himself, or through cross-examination, or by reliance on a statutory provision, to put forward what is commonly known as his defense. Defenses may be common law defenses, sometimes called special defenses, or they may be statutory defenses, where the statute under which the defendant is charged provides a defense, providing that the defendant is able to meet an evidential burden. And we dealt with evidential burden in an earlier episode. Some defenses may be complete defenses, others may be partial defenses. The list I am about to present is by no means exhaustive, as in many cases the defense proffered at trial will depend on the facts and circumstances, and in some cases the defendant's own peculiar circumstance and characteristics. The first defense that I would like to discuss is the defense of innocence. This may be surprising, but it should not be controversial, because a defendant charged with a criminal offense may be completely innocent. And innocence is one of the simplest forms of defenses to criminal liability. This defense is raised when a defendant asserts that he or she did not commit the crime. The prosecution has to prove every element of the crime charged, and they must prove it beyond a reasonable doubt. The defendant in law does not have to prove his innocence. However, a defendant charged in criminal proceedings may decide to offer testimony or documents or other evidence in support of his innocence. And there are cases where persons charged with criminal offenses have been found to be absolutely innocent because the allegation against them was concocted. The second defense that I would like to discuss is the defense of lack of age, or in Latin, Doli Incapax. Now, this was abolished in England and Wales in 1998 by virtue of Section 34 of the Crime and Disorder Act. But this defense is available in common law jurisdiction. The defense is based on the presumption that a child under the age of 14 years is incapable of committing a crime. This presumption could be rebutted. For children between the ages of 10 to 14, if the prosecution could satisfy the court that the child knew what he or she was doing and knew that it was wrong, and the child was not merely a mischievous or naughty child, but what he or she did was deliberate, intentional, and with a full knowledge that he or she was committing a criminal act. The common law position, in my respectful view, remains the law in the Turks and Caicos Islands. I am not aware of any statutory provision abolishing the defense of Doli Incapax. And so, in my view, it remains the law in these islands that a person under the age of 10 in law is incapable of forming the criminal intent to commit an offense. The next defense I would like to speak about is what I call constitutional violations. And while these are not a defense per se, they are very important in criminal law and criminal proceedings, and there are more applications in criminal trials to exclude evidence because of the way the evidence was collected or the way the defendant was treated by the police. For example, the prosecution may seek to rely on a confession made by the defendant. The issue may arise if the defendant was coerced into giving or making the confession, if violence was used against him, if threats or promises was made, and as a result of those threats and promises, the defendant made the confession. If an application to exclude the confession is successful, this may force the Crown to reassess its entire case to see if, in the absence of the confession, if they could continue the prosecution against the defendant. There may be instances where exhibits or fingerprints or DNA evidence or other forensic evidence collected by the police are being challenged by the defense, either because they were unlawfully obtained, or an issue of contamination or chain of custody, or the integrity of the exhibits themselves may come into sharp focus. And so the defense may make an application to have these exhibits, excluded. And again, if the application is successful, the Crown will be forced to reassess its entire case to see if, in the absence of one or more pieces of exhibits in question, if the case against the defendant should proceed. There may be issues where the allegation is that the defendant's constitutional rights to an attorney or his right to silence has been violated. There may be issue where the prosecution may intend to rely on certain verbal admissions allegedly made by the defendant, and the issue may arise if, when those purported admissions were made, if the defendant was properly cautioned under the judge's rules, and if not, did these admissions fall within any exception of the hearsay rule. I move on to the defense of alibi, and this defense, from a layman's point of view, is often mistaken and misused. But this is simply where a defendant charged with a criminal offense alleged that he was somewhere else at the material time of the commission of the offense. The defendant has an evidential burden, and you may remember we dealt with the issue of evidential burden in an earlier episode, but he has that evidential burden to produce evidence of his alibi, and the Crown or the prosecution has a duty to disprove beyond reasonable doubt the defense of alibi, and the defendant may discharge this burden by calling a witness known as an alibi witness, who may be able to verify that the defendant was at a certain place at the time when the offense was committed, and that he was nowhere present at the commission of the offense. Or the defendant may be able to produce documentary evidence. He may be able to produce an airline ticket or surveillance footage or receipt from a restaurant, a store, or movie theater, or phone records that he was elsewhere when the offense was committed. Now, there are certain offenses where the requirement for the presence of the defendant at the scene of the crime at the time it was committed or the time it is committed is not necessary. And in relation to those offenses, it is likely that a defense of alibi will fail. For example, an offense of conspiracy. The key to an offense of conspiracy is the agreement. So a defendant could agree, for example, to an armed robbery. He could be part of the planning and the organizing, but he was not physically present at the time when the offense was committed. Nevertheless, he could still face criminal liability because of the agreement. Or the offense may be one of importation of prohibited substance, prohibited items, or importation of drugs. And at the time when these prohibited items enter into the Turks and Caicos, the defendant does not necessarily have to be present at the airport or the port of entry, but the very act of him importing the items into the Turks and Caicos, even if the defendant were to send someone else to collect these items, it is highly possible that the defendant could still attract criminal liability. The Criminal Procedure Ordinance and the Criminal Procedure Rules of the Turks and Caicos Islands require the defense to serve a notice of alibi and the prosecution within a specified period of time. And this is so because of the duty and the prosecution to disprove beyond reasonable doubt the defense of alibi once raised by the defendant. So if a defendant serves notice of an alibi defense, then it is incumbent on the prosecution or the Crown to investigate, to check it out, to see if the defense that the defendant puts forward, if it pans out. And in all likelihood, if the defendant defense of alibi is watertight, is credible, then the prosecution may have difficulty in mounting a successful prosecution against the defendant. We now look at the defense of consent. Consent and a reasonable belief in consent, and I will explain in a moment. In law, consent can be a full or a partial defense in certain types of crimes. In the cases of sexual offenses, and particularly the offense of rape, consent is an absolute defense. It is for the defendant to show that he held a reasonable belief that the complainant consented to sexual intercourse, which involves penetration. However, consent must be informed. A person must not consent to an act or acts blindly without being aware of all the circumstances and the risks involved. Example, in the case of the Queen and Dyker 2004 Queen's Bench Court of Appeal Criminal Division, the defendant in this case was HIV positive, and he had unprotected sex with 2 women on a number of occasions. So clearly they had an ongoing relationship. Both contracted HIV. The defendant never disclosed his HIV status to the woman. The defendant was charged with inflicting grievous bodily harm, contrary to Section 20 of the Offences Against the Person Act of 1861. His defense of consent was withdrawn from the jury by the child judge. He was convicted and he appealed against his conviction. The question for the court was whether in the circumstances the 2 women consent was valid, and Judge LJ said the question for decision is whether the victims consented to sexual intercourse, which as a result of the defendant's alleged concealment was given in ignorance of the facts of the appellant's condition. If this necessarily amounted to consent to the risk of being infected by him, the court concluded that the defendant would have had a defense had the woman known of his condition and agreed to sexual intercourse because they were prepared to run the risk involved. Nevertheless, the court held that the trial judge had been wrong to withdraw the issue of consent from the jury. So, in circumstances where consent is given, but it is given in ignorance, it was given in the dark, without the person who is consenting being aware of all the facts and all the risks and all the circumstances, that consent could be held to be invalid because it is not informed consent. And finally, in this first episode of defenses in criminal law, I would like to discuss the defense of self-defense. And this is where some reasonably justified action is taken by someone to protect themselves, their property, or to protect another person. The person seeking to rely on the defense must believe that his or her action is necessary. The attack must be imminent or ongoing, and the force that is used in defense must be no more than necessary to avoid the attack. The defense must be rebutted beyond reasonable doubt by the prosecution in order for it to fail. In the case of Palmer and the Queen of 1971, a case decided by the Privy Council, Lord Morris said the following: "It is both good law and good sense that a man who is attacked to defend himself. It is both good law and good sense that he may do so, but may only do what is reasonably necessary. If there has been an attack so that the defense is reasonably necessary, it will be recognized that a person defending himself cannot weigh too nicely the exact measure of his necessary action." So while the court has recognized that a person has a right to defend his or herself if they come under attack or if an attack is imminent, and while the court recognizes that the person in the heat of the moment cannot weigh up too nicely all the circumstances in actually administering the force to defend his or herself, it is still incumbent on that person to use no more force than is necessary. And once the person relying on the defense only use force that is necessary and force that is justified in the circumstances, then the defense should come to his or her aid. Here is where I will leave it for today, and in the next episode I will continue with defenses in criminal law.